Okay, we're gonna get started. Thank you guys for coming. I know there's a lot of other events today, and it's Halloween and it's Thursday, so I appreciate it. We are very lucky to have Karen Houppert with us here today. She wrote Chasing Gideon, and she's been a contributing writer at the Washington Post for many years. She's worked on The Nation, Newsday, New York Times, Mother Jones, Salon, and The Village Voice, among other publications. She has 3 total nonfiction books, and she lives in Baltimore, Maryland. We're very happy to have her as part of our Gideon series this semester. We also have 2 more events coming up in the next couple weeks. We have a panel with Outlaw on November 5th, and that's called November 4th, I'm sorry.
Monday.
November 4th, which is Monday. It's on the constitutional amendment in Indiana on same-sex marriage. And then we also have November 14th, we have a prohibition mixer with FedSoc. So more information to come on those. So I'll introduce you to Karen Houppert. Thank you.
Hi, thank you for having me, and thank you for coming on your lunch hour. And I would like to talk to you guys a little bit about Chasing Gideon, and then I'll tell you a little bit about the background, because I'm not sure how familiar you guys are with the original case. And then I will read an excerpt from the book and take a few questions. So my talk's about, 40 minutes or something, so we'll have some time for questions. To begin with, as probably most of you know, Clarence Earl Gideon was arrested in the summer of 1961 by cops in Panama City, Florida, for breaking into a pool hall, stealing some change from a cigarette machine and a jukebox, some bottles of beer, and a couple bottles of soda and wine. He was 51 at the time, and he'd been arrested a lot in the past for petty crimes, including theft and gambling. And he'd done time before, and in the process he took some trouble to educate himself about the law, and he learned one important thing, which is the law is pretty complicated. So when he went before the judge, he said, laying the groundwork for the case, the judge asked him if he was ready for trial. Gideon said no. Why aren't you ready? The judge asked. I have no counsel, Gideon replied. So that was the basis of the case. And I thought it was really interesting. I'm sure most of you have probably read Anthony Lewis's book, Gideon's Trumpet. If you haven't, you should. It's a really terrific book, and he writes a lot about both the Supreme Court and the man behind that case. And one of the things I think is interesting too, and the reason I put it up there is, here's this guy, here's his penciled plea to the U.S. Supreme Court on prison stationery, rife with errors and spelling mistakes. But at the same time, it had a strange kind of elegance to it. He wrote, "It makes no difference how old I am or what church I belong to, if any. The question is, I did not get a fair trial. The question is very simple. I requested this court to appoint me an attorney, and the court refused. All countries try to give their citizens a fair trial and see to it that they have counsel." It was interesting when you look at the original case to look at who the Supreme Court assigned to represent Gideon, because even in their assignment of counsel, they were clearly giving Gideon a real leg up. They really, in some ways, were signaling that they wanted his case to succeed. They gave him Abe Fortas versus Bruce Jacobs. And Fortas, as I've kind of mapped out here, he's 52 years old, partner in Arnold Fortas and Porter, who one of the folks in our audience recently worked or interned there this summer. So a very powerful law firm with lots of resources at its disposal. He was a Yale Law School grad. He'd worked with New Deal luminaries. He'd been Under Secretary of State. erudite, intellectual, art connoisseur, violin virtuoso, very wealthy, and very, very well connected in Washington. On the other hand, the state of Florida had Bruce Jacobs, who's 26 years old, Stetson Law School grad. He had just taken a new job and was commuting 250 miles to work at the law school on weekends. His wife typed his briefs. And the morning before arguments on January 15th, he had to arrange for admission to the U.S. Supreme Court bar. He had never argued before them before. So between that first sort of advantage that the U.S. Supreme Court gave him, there was a couple of other things going on at the same time. 22 states signed an amicus brief on Gideon's behalf, and that was actually a little bit of a misfiring on the part of Bruce Jacobs, perhaps his first misfiring, in that he, in preparing for the case, he had sent out letters to all of the attorney generals of all of the states and seeing if they would sign an amicus brief. And 22 states actually wrote back and said, actually, we're going to write one for the other side. And they were led by Walter Mondale, Attorney General of Minnesota at that point. So this was, the culmination of years of back and forth regarding the Sixth Amendment to the Constitution. So they appeared poised to overturn Betts versus Brady. And then another thing that kind of changed the lay of the land was that in August of that year, U.S. Supreme Court Justice Felix Frankfurter retired. And so that made some of the other players quite hopeful about this case. In the end, it was a unanimous decision. Hugo Black said, there can be no equal justice where the kind of trial a man gets depends on the amount of money he has. 50 years ago, people were hopeful and they were optimistic about this. There's one quote in the oral arguments that I like to invoke in which Abe Fortas said, a couple of the justices were querying him, and what are you saying? You're saying that anybody who wants an attorney, even if they have like a traffic ticket, can just, has the right to an attorney? And Fortas was like, he said, yeah, maybe you say walk down the hall to room 101 and your attorney is in there. And he kept repeating, it'll work, I know it'll work, it'll really work. And he was right for a while. For a while, it did work. The public defenders were able to manage the caseloads, et cetera. But in the intervening 50 years, as I discovered when I started reporting my book about 2.5 years ago now, a lot's changed. So there's a major crisis in the court. I think a lot of you who've done law clinics or volunteered or interned are aware of this crisis in the courts. And it's attributable to a number of things. One is the numbers of incarcerated have soared. They've shot up from 300,000 30 years ago to over 2 million today. In 2012, last year, some states like Louisiana, 1 out of every 86 residents has served time. And Stephen Bright, who heads up the Southern Center for Human Rights down in Georgia, said he was standing outside a courtroom one day looking at the mostly black men being unloaded from a bus and shuffling into court in shackles. And all he could see in his mind's eyes were these images of slave ships. So why is that? Here's a visual representation of what those numbers look like. So what's happened in the intervening years? 1, the war on drugs. 2, tough on crime policies and mandatory minimum sentencing. Prosecutors overcharging, and an increasing tendency to hold more people pre-trial. This is a picture I reported in the course of my reporting. I reported on several states. Originally, I went in, I was going to write about 50 states, and then it became like 20, and then it became like 10. Ultimately, I was able to cover 4 states. So I wrote about Florida, Louisiana, Georgia, and Washington State. So when I was down in New Orleans, one of the things I noticed, I'm just taking a picture, a random picture of mine of the courthouse, and wondering, why hold nonviolent criminals pre-trial when there's no flight risk? Because that's also really packing the jails. And this is the view across the street from the the New Orleans courthouse. And most courthouses in America, right? I mean, I don't know what the one looks like here, but almost all of them, the blocks surrounding the courthouse look a little like this. I also took this one because my husband's name's Steve. And I thought, So in the course of talking to public defenders, politicians, judges, activists, there was basically 3 areas of reform that they identified, or they fell into these categories. The structure of the system, and there's a lack of independence. Many places, public defenders are beholden to local governments or judges and are pressured to push large volumes of cases through the system quickly and cheaply. There's also panel systems. I'm not sure what the situation is in Indiana, but many places the lawyers can be appointed by the judges, so they're beholden to them and thus disinclined to fight for their clients or to anger the judges who controls their work and money. One judge in Michigan told a story about how he was talking about the independence of public defenders. Another judge said to him, "Well, if I don't appoint the lawyers, who will fund my campaign?" So there is a clear connection in many people's minds that that's not working. Another aspect of this is the culture of the public defender's offices themselves, and perhaps I would argue the country at large, in that there is a low expectation for what poor people deserve. You'll hear bandied about, oh, he got the Cadillac defense, and people will be furious at the amount of money spent on a client and his defense if he's using the public defender system. Another aspect of that is more internal, and it comes from the macho culture of the public defender's office. So some of you who've already been working with public defenders maybe have encountered that, and that is the, shut up and stop whining about your caseload, get over it, move these people through quickly. And also, of course, with that kind of culture and caseloads, pleas are a much easier option for lawyers when you're overworked. Roughly 80% of defendants in the United States courts rely on public defenders. 94 to 97% of them plead guilty, depending on whose statistics you're looking at. And often that guilty plea takes place after a 10-minute conversation with their public defender. There's a lot of encouragement from the bosses themselves, chief public defenders, and judges to keep the docket moving, keep things going, to clear your desk, etc. So there is this attitude sometimes of efficiency at the expense of justice. And finally, funding, which is that states have not invested in public defense. And that aspect of the question interested me the most, I think, because as a journalist, I was curious about why that is and what people's attitudes were about public defense in the United States. So one of the things about funding, as you can see here, it's tied to caseloads. And caseloads came up over and over and over again as the major crisis in public defense in almost every state in the country. So this is a common image that you guys may have seen. So when you look at funding and caseloads, here's a sense of what the caseloads are for misdemeanors, felonies, and juveniles, and versus what the recommended caseloads are. So the American Bar Association, for example, recommends 150 felony cases a year for an attorney. But in some places like Miami, well, with misdemeanors in Miami, some of the public defenders carried caseloads as high as 2,225. And felony cases as high as 700 per year in Dade County in 2008. And these are attorneys, not to discourage anyone, but who were working for a salary of $42,000 is their starting salary there. I spoke about a month ago to 2 groups in South Carolina, and they've been involved in a reform effort, but they told me that their average caseload for felonies was 476 per year. And one sort of analysis that was done by some reporters at Mother Jones said that about 6,900 more public defenders would be needed to complete the current caseload with this 150 recommended caseload. So it's no wonder, given these circumstances, that many public defense lawyers are sucked into this meet 'em and plead 'em routine. It's a large reason why 90 to 95, 95 to 97, I'm not sure, 90 to 97 people plead guilty. One attorney, Tanya Green, said, you've got so many cases, limited resources, and there's no relief, she says. You go to work, you get more cases, and you have to triage. So why don't public defenders just turn down cases they don't have time for? 60% of the state systems don't allow that. You can't really do that. They are in the midst, they've been for a couple of years in Miami trying to do just that. It's crawling through the courts, but they haven't had a lot of success. Plus, there is the ethical dilemma that the public defenders face, which is there's no one woman, this same woman, Green, explained it to me, I'm quoting her, there's no lawyer that becomes a public defender wanting to disservice their clients. Advocates for reform say there must be better pay for contract attorneys and other non-full-time PDs who assist with case overflows. She really felt like it was, you're triaging cases, you have an ethical obligation to provide good counsel, and I think it eats up a lot of public defenders, at least a lot of the ones that I talk to, because they actually want to do a good job, but the circumstances make it really, really difficult for them to do the kind of legal representation that they want to do for their clients. This is just a look at how much the country spends on public defense compared to corrections, police, etc. And with there's a real disparity in resources between the prosecutors and the public defenders, and that's across the board. That's money for investigators, paralegals, lab work experts, etc. Nationally, the money spent on prosecution is about twice what's spent on public defense in most states. So, and this is just a quick look at where we fall internationally in terms of spending. But who cares, right? We all know this. I imagine a lot of you know this. And one of the things that was interesting to me when I was reporting this was that I'm an outsider. I'm a journalist. I'm not a legal scholar or an expert. So I had written for many years around the law. I'd written about incarcerations. I'd done stories on juvenile prisons. I'd written about some restorative justice programs, etc. And became interested to discover that pretty much everybody that works in the legal system is aware that there is this huge problem, and yet nothing gets done. So there's a tremendous amount of research out there. There's been studies and reports and blue ribbon commissions and white papers, et cetera, describing the nature and the scope of the problem, but nothing gets done. And what I realized is that most Americans, I think, don't even know what public defense is, let alone why it matters. And I always try out when I'm working, reporting stories. I try out my anecdotes or my stories on friends and, everybody I talk to. Just, it's my way of seeing what works and what doesn't. So when I'm talking, at a cocktail party to somebody, oh, what are you working on now? Oh, I'm working on this book about indigent defense and, this Gideon case and public defenders and this. And their eyes would glaze over and they're like, they're looking just over my shoulder to see if there isn't somebody a little more interesting to talk to at this party, right? And lest you discount that as me just being boring. My previous book I was working on was about sort of menstruation, a cultural history of that, and a look at the sanitary protection industry. And granted, a lot of the men just kind of walked away when I talked about that, but most of the women were like, oh, when I got my period first, you got this response from people. They were engaged. With this, I really felt like most people in this country don't really even know what public defense is. And to me, that idea is linked to why isn't there adequate funding for this? Because I think there's a real lack of political will, and that comes from a lack of knowledge. In trying to figure out how to craft my book, one of the things I wanted to do was to stay away from the legalese and the jargon and all that sort of stuff. So I started, okay, don't call them indigent, call them poor people. Don't call them juveniles, call them, the 12-year-old boy. And sort of changing the way that I talked about things, and also beginning to think about how I was going to tell the story and how I was going to make people care about this issue. And what I decided to do was really to tell this story narratively. So to try to focus on the clients. I focus a little bit on the public defenders, but mostly I focus on the clients themselves. And part of the reason I did that was it took me about 6 months to kind of even figure out what was going on in the courts, right? As I said, I'm an outsider, I'm not an expert, etc. So I would find myself sitting in court next to some public defender and having no idea what's going on in front of me. Like, what are they talking about? What did he say? What does that mean? Needing really an interpreter. And so I was like, oh my God, how am I going to write this book? I don't know what's going on. I'm not an expert. And then I realized, sitting on the other side of me is the client. I'm wedged between the attorney and the client. They don't know either, right? And actually, that was very much the point of the whole thing, is that you really do need this attorney to explain to you in great detail, in non-jargon, what's going on in court, and that you cannot navigate the law by yourself, right? So I decided to use that idea and to really begin to look at what this experience of going through the courts was like for clients. So my book focuses on 4 people. This is a guy I wrote about and I'm going to talk to you a little bit about them. I chose people who well, I don't know, as journalists you kind of try to choose people who are articulate and interesting, and but who also had cases going through the system that exemplified some of the systemic problems, because what I was trying to do was weave my narrative in with context. I have this idea that people are moved to action emotionally through storytelling, but learn how to act based on understanding the broader context of the situation. So I kind of toggle between those two things. So this was one guy I wrote about out in Washington State named Sean Replogle. And Sean was 18. He was driving his first car that he just bought like a week earlier, didn't have insurance on it yet. Went to cash his paycheck to buy the insurance. and got into a car accident. And it was not his fault. Here's the intersection where he got into the car accident. It was not his fault. He had the right of way, but an elderly gentleman pulled out in front of him, and Sean hit the guy. And at first, Sean thought he was okay. And, you know, he got out of the car and the man was walking around, etc. But they took the ambulance came and they took him to the hospital. And 2 weeks later, the man died. And so Sean was charged with vehicular manslaughter. And he was lucky in that he had a public defender that actually really went to bat for him. She was carrying 101 felony cases at that time. Her name was Carol Dee Huneke. And the prosecutors in Spokane at the same time carried caseloads of between 16 and 36. So she went to the judge at one point. She'd done 4 trials in the last month and a half. And she said, I'm not ready for this trial. I can't, you know, I need to delay it, etc. The judge said, no, you have to go. This was like a Friday. You have to go to court on Monday or I'll hold you in contempt. And Carol has never admitted to me that she actually called the press in. I suspect she probably did. But anyway, a reporter was there. And she prepared a whole statement. She found out all the data about the prosecutor's office, their budget versus public defenders. She found out information about their caseloads versus public defenders, etc., and said, it would be ineffective assistance of counsel for me to go forward at this point. I can't possibly do it, etc., etc. So the judge actually ended up giving her a little more time after this. And what she found out in her extra bit of time was that the police had cooked the books a little bit, or the statistics, in terms of measuring the skid marks on the road, and that using that to determine the speed that Sean had been going. So Sean had been speeding, but not nearly as much as they had said. And then she talked to the man who died's family doctor and found out that he had died of an infection from an operation on a hernia, and that the hernia was a pre-existing condition. And in fact, the emergency room doctors had called him and he advised against operating. He said, yes, I know about this hernia. It's been there for a long time, but I thought his health was too fragile to operate. And the emergency room physicians did it anyway, and the man got an infection and died. Anyway, so the jury actually acquitted Sean in under an hour. But I used Sean's case to also look at how different your representation can be based on whatever county you happen to be arrested in. So Sean's in Spokane, and then about an hour away in a town called Moses Lake, there was another case going through the courts around the same time, and this was about a kid named A&J. And he was a 12-year-old boy who was accused of playing a game called Icky Poke You with a 5-year-old boy. The 5-year-old said the 12-year-old asked him to sit on his lap and play Icky Poke You, and the 12-year-old put his hands down his pants. Police came about a month later and interviewed A&J, and then filed these charges against him. A&J got a public defender in Moses Lake. The public defender was carrying 240 other criminal cases, and for a total of 440 cases, actually, because he had some other cases in the juvenile courts going on. He was, again, the recommended amount by the American Bar Association is 150. And this man didn't make a single call on behalf of his client. He doesn't do any basic background check on any of the people involved. He doesn't speak to a single witness. He files no motions. He makes no request for discovery. He just advises the kid to plead guilty. And he actually, the parents can't even get him to call them back. You know, obviously they're frantic and calling him, and they can't even get him to call him back. So this a public defender just says he should plead guilty. It'll be fine. The parents are like, well, what? Well, is he gonna, have to register as a sex offender for the rest of his life? And the attorney's like, no. It's either 18 or 21. I'm not sure which, but he can have his record expunged at that point. And so the parents did it, but then it turned out that in fact his record is not expunged, and he was sentenced to 4 to 9 months in custody. He was forced to undergo HIV and STI testing. He was required to register as a sex offender, had a monitor follow him at school every day, and was also required to undergo therapy where he had to acknowledge his guilt. So his parents were, furious, and they ended up hiring a private attorney. Meanwhile, the public defender, this man named Douglas Anderson, was working on a flat fee contract. You guys know what that is? I don't know if you have that. So basically, it's he's given, in this case, $162,000 a year for all of the cases that the county throws his way, all of the juvenile cases, in this case 440. From that has to money for any administrative or paralegal, which in his case was his wife, had to come. And any money for experts or investigators or any of that has to come out of that same $162,000. So there's a clear disincentive to aggressively pursue a case. So, that's what happened. And that happened, in Washington State. And I could find no press on it. I mean, I just kind of randomly stumbled on this case, and it was so ordinary that not a single newspaper even covered it. It was bizarre to me. And this is, as I said, less than an hour away from where Sean was in Spokane. So what this case, though, ultimately did was push Washington to reform some of its public defense requirements. And right now, it hasn't even been a year, it's been maybe 6 months. They're requiring public defenders to personally attest to the fact that they are not exceeding caseload limits. So some states have tried having the chief public defenders attest to that on behalf of their employees, which hasn't worked very well. But in this case, before they, begin a trial or anything like that, the public defender has to sign something saying that they are not exceeding the caseloads. So as I said, this is brand new reform effort. Everybody's pretty optimistic about it, but no one knows yet how that's going to play out in Washington. So meanwhile, I'm just going to talk about one more state, which is Louisiana, and specifically I'm going to talk about New Orleans, because they have had some major problems there related to funding in the last couple of years. So they had this budget crisis among the public defenders, and had to lay off 21 public defenders, which was their entire conflicts division. So just to recap, a conflict attorney is one if there's two defendants in a case, like two guys rob a 7-Eleven, they can't have the same attorney. They're assigned a conflicts lawyer. So within the public defender's office at New Orleans, they had these 21 conflicts attorneys. They laid them all off. And what that meant was that there were more than 540 clients without representation. So these clients basically just sat in jail, a lot of them. One man I spoke to in jail down there had been 16 months without an attorney. And I don't know where the ACLU was. My editors kept asking me that. There's got to be, where's the ACLU? I'm like, I don't know. But I know this guy's been in there 16 months, and lots of people that I was talking to. What they did was, it was a bit of a linguistic trick they played, in that they didn't say these clients did not have representation. They said they were on a waiting list for pro bono representation. So whatever they called it, these guys, many of them, did not have attorneys for months and months and months. And then at one point, a judge down there named Judge Hunter intervened, and he said, they have to have a lawyer. This is, I'm going to set them all free if you guys don't get them an attorney, if they don't have representation. And he actually sent out a call for pro bono lawyers, and he sent letters to sort of all these top mucky mucks in the state who maybe had a law degree but hadn't practiced. A lot of politicians, the publisher of the local newspaper, corporate presidents, and said, you have to come in and represent these guys in criminal court. Some of them did. But anyway, that didn't work very well. But what did happen was they were relying on pro bono attorneys, and many of these pro bono attorneys, had no experience in criminal law. For example, the guy I spoke to, Clarence Jones, who had been arrested on a burglary charge, the one who'd been in jail for 16 months. He got an attorney specializing in insurance law. And he was a very colorful chap. I talked to him, and he's like, talking about his workload, he's like, I'm up to my armpits in alligators, but I'm going to work this case. So, anyway, so he gets this insurance lawyer. And one of the Tulane law professors I spoke to down there, Catherine Mattis, she said, having a tax attorney and property lawyers tackle criminal cases is far from ideal. You don't ask the cardiologist to do your brain surgery. Nonetheless, that's what these guys had. One of the things that I decided to do in New Orleans, I wrote a lot about the guy I spoke to you about, Clarence Jones, and I kept circling around and returning to this question of how can everybody know about this and nothing gets done. There has been a concerted effort this year, as some of you have maybe noticed, to use the 50th anniversary of the Gideon decision to explore our progress and lack thereof. Also, there's been efforts to file class action lawsuits. New York State has one going on, which New York City has a pretty excellent public defender program and legal aid program. But if you are arrested for the same crime in one of the upstate counties, your chances of getting off plummet tremendously. So it's really a mishmash of quality representation. There's a lawsuit going on there, and several other states. There's been a push for the federal government to get more involved. Some people are talking about like the highway programs, right? How states got funding from the federal government if they instituted speed limits of 55 or less, right? So couldn't the federal government put money toward public defense and tie it to a set of reform efforts? So that's another conversation that they're having. There's talk about efforts to restructure the funding mechanisms. For example, in New Orleans, one of the ways the public defender's office was financed was through traffic tickets and parking tickets. And on the heels of Katrina, when the city was empty, the entire public defense system shut down. I mean, they just left. They wouldn't get paid. There was obviously no cops out there ticketing cars. So the whole system completely crumbled. And there's many states and counties that have rigged up fairly unreliable funding streams for this. So that's another conversation that's going on. There's efforts to eliminate disincentives to aggressive representation and also to increase public understanding of the crisis. So, So, as I said before, one of my efforts to kind of increase public understanding was writing this book and making sure that I focused on real people whose lives were affected by this troubled system. One of the men I wrote about also down in New Orleans was this man named Greg Bright, who was the one here who told me they worked or applied or interviewed with the Innocence Project or something somebody. Okay. So Greg Bright was someone who was wrongly incarcerated for 27 years and was ultimately freed by some lawyers from the Innocence Project down there. But I'm going to tell you a little bit about his story, which is that in 1975, Greg Bright was sentenced to life in Angola based on the single eyewitness who, as Innocence Project lawyers later discovered, this woman, the witness, had been repeatedly hospitalized for paranoid delusions and schizophrenia. The trial was conducted by some lazy public defenders down there. The public defender was friends with the judge who heard the case. He'd actually been arrested with that judge for illegal gambling prostitution party that they were having in a local hotel. Anyway, they were clearly good friends. It was a two-person murder trial. It was conducted in under 2 hours. No witnesses were called. There was no opening argument, no closing argument. And Greg spent the next 27 years in prison for a crime that he didn't commit. And I want to end by just reading a little excerpt from my book about Greg and one of my conversations with him. And then we can talk more if you guys have questions. Let's see. So today, Greg Bright, 56, sits on the cement porch of his yellow clapboard house in New Orleans' 7th Ward and rests his hand on the head of his yellow dog, Q. It's 2012, and he often finds himself musing over the notion of time. Time past, time lost, time wasted. It feels like a minute since I've been out here, he says. It took some time to adjust to life on the outside, he admits, and once, on a dark, rainy morning, as he found himself biking 7 miles in the rain to his miserable job working the line in a chicken plant in Mississippi, he felt real despair, just recognizing that he was 47 years old and had never owned a car. He tried hard to dismiss the sobering thought that, arrested at age 20 and doing 27 years of time, he'd been 7 more years in prison than I'd been on the streets. Sometimes, he says, it's little things like that that really threaten to drag him down into sorrow. So he chooses to do something that both keeps those wasted years fresh in his memory, yet also mitigates the sense of powerlessness he sometimes feels. He helps to educate others in the hopes that his story will spur reforms. He's not an educated man. His formal schooling stopped in 6th grade, but he's one of dozens and dozens of ex-cons who form a vital link in the post-Katrina criminal justice reform efforts through various organizations. Greg tells his story to students, activists, politicians, church groups, friends, strangers, anybody with time to spare and an inclination to listen, doggedly putting a face on an abstract idea, injustice. There he is on his arrest. There he is when he was let out. He has no shoes and carries all his worldly possessions in a garbage bag. So on this particular morning in May 2012, when I'm talking to him, he tells this story to me for the 4th time. He's deeply preoccupied with the judge who repeatedly denied his requests over the years, the same one who was on the team prosecuting his murder in 1976. The very month that Greg was released in 2003, the judge died. Greg goes into his house to retrieve the judge's yellow and tattered obituary that he has kept these 9 years. He reads it, as he has done hundreds of times. The obituary, like all obituaries, says nice things. The judge may have been a good man, Greg muses. He might have been a good husband, a good father, a good friend to many people, and I'm sure he was. But people may be saying the same thing about me. Q, the dog who lies panting at Greg's feet, lifts his head for a moment to look around, as if considering the matter. Then he lowers his head to rest his muzzle on Greg's shoe. But because I'm not a lawyer, but because I'm the little guy, man, you step on my head and crush me. I don't have money or influence or even God on my side. Interestingly, he saves most of his venom for the judge and the old boys network that got him a lawyer, but one friendly with the judge and disinclined to even work up a sweat when it came to Greg's case. Gideon guaranteed him an attorney, but a flawed indigent defense system and a lackluster lawyer rendered that almost meaningless. But why, he says. You know why? Sometimes I think about it. He wonders what the solutions are to the troubled criminal justice system here, to the high incarceration rates in the black community, to the racism and power imbalance. He talks on and on, indignant, furious, rambling, but right. He grows heated. Mostly he wonders how one draws attention to these problems, how change happens. Sometimes I think about what is it, this Mahatma Gandhi thing, this passive resistance, he says. They crack your head to the skull, you get up and say to the man, thank you. He cracks your head again. You got to be an animal to continue that. That's what I felt like that judge was doing to me every time I came forward. It's an outrage. He pauses, inhales, collects himself. But I'm not talking from bitterness. He says this, and yet how can he let go of bitterness? Like a dog licking a wound, keeping it open and raw, Greg Bright revisits his past, alternately trying to decide whether he and the city of New Orleans get to have a happy ending or whether their shared story is a tragedy. Is it a happy ending because he now sits on the porch of the modest little yellow house he owns in the 7th Ward, quote, my pot of gold at the end of a rainbow, end quote, as he once called it, after finally receiving $190,000 restitution for being wrongly imprisoned? Or is it a tragedy because he wasted 27 years of his life behind bars? The criminal justice system in New Orleans, indeed the nation, seems similarly poised between plot twists, an ending that could go either way. Thank you. Does anybody have any questions about public defense or journalism or anything like that? Yeah?
Yeah, we've learned a lot about this week. But one issue I haven't heard talked about is the privatization of the prison systems and how that's creating a new kind of countervailing pressure to increase criminalization of things, make profit. Mm-hmm. Can you talk about anything you've run up against or discovered in your travels?
Yeah, the chapter I write about in Louisiana, I do write about that quite a lot because Louisiana is one of the worst offenders in that regard. Like their prison system that are mostly privatized, and it's a complete disaster. I mean, they're not even giving these small towns that are courting the prison industrial complex, whatever, they're not even giving them that much per prisoner. I want to say it's like $25 a day or something like that. But they're a complete disaster. There was a huge and very good investigation in the Times Picayune in New Orleans when I was down there reporting that wrote a lot that, you know, that they really delved into this issue. And you're right. I mean, that's the counter tension to the conversation that's going on, I think, in places all around the country about like decriminalization of marijuana, or whether that would be a finable offense versus a misdemeanor or whatever. So it's definitely a huge part of the conversation, and I don't think that there is anybody except the owners of those prisons that are arguing that this is a good system. It's, deeply troubled. Yep.
Throughout the course of your research, did you encounter any public defender systems or any of the defense models that you liked, so that you thought had potential for?
Yeah. The federal public defender system is a very good one, although they've recently been a bit strapped and had to do furloughs and stuff because of sequestration and other things. But that's often held up as the gold standard. The other one is Washington, D.C.'s Public Defender Office, which is adequately funded. There's the Bronx Defenders. There is a movement among public defender offices in some places. Baltimore, which is where I'm from, is just now kind of dipping their toes into this water to provide more holistic defense. And so that effort, and I think Bronx Defenders were sort of in the forefront of this in terms of, having an office that has a social worker right there, that really tries to delve in and assess more broadly what the client's needs are. Is this someone who needs to actually get some help with drug addiction? How can we do that? Is this person with a housing issue? Is this a person with an immigration issue? So there is a real effort among some public defenders' offices to look more broadly at why this person landed in court in the first place. And so those are a couple of the places that seem to be doing good, interesting new work in this area. So, anybody else? Yeah?
Yeah, you said after your A&J started at Washington after that is attempting a few reforms, and I was wondering, given the fact that politicians get elected on being tough on crime and there's a lot of incentive towards having this sort of system prosecute and incarcerate people, and they're not generally sympathetic as far as the public view is concerned, what is the catalyst for creating reform? What is eventually going to get these states to try to reform their systems or get them out of decline or try to use case law?
Yeah. There's definitely conflicting theories out there about what will drive the reforms. Many people out there think no one is going to take a step toward reform unless they're forced to by lawsuits. So thus, that's one avenue of attack, is to start filing these class action suits and other suits. Myself, I think it's connected to this idea of people not really understanding what's at stake. I really do. I mean, I'm possibly naive and optimistic, but I really actually think that people care about fairness, but they just don't actually understand what's going on. Like, I don't think the general public, as I said, really knows what's going on. So those politicians can't move to speak out for adequately funding public defense unless they have the public's backing in some ways. And they're facing, as you said, these law and order politicians who, lock them up, throw away the key mentality. So there has to be, I think, a change in public perception as well, because we've seen a change. I mean, there used to be shows about criminal defense, like, I don't know, I'm trying to think of public defenders, Ironside or Matlock or whatever, versus now it's all like Law and Order or, trying to think what the other ones are. But really, like, even in our culture, we've shifted to really emphasize prosecution over defense. And I think that's not insignificant, and it's telling about what the cultural conversation is in the country right now. So that has to change too. That's harder to do. Oh, can I ask this guy, since you already...
Do you see the next big move coming from the courts, from the top down, or from the public, from the bottom up?
I'm hoping they'll meet in the middle. I do think it has to happen on multiple fronts. And even the court cases really help educate the public too, because when they get press, people are genuinely shocked when they read about things like this A&J case, So I think that the lawsuits definitely are helping drive the public conversation, but that it's also important for I think, as I said, the legal community to make sure that their stories are getting out. And one thing that I've done when I've talked to public defender organizations and stuff too is really urge them to open up to the press. Like, journalists do this thing with the cops called a ride-along, where it's maybe off the record, but they spend the day and they, walk in their shoes for a while, and it's very useful, right, for journalists to see that. And I, encourage them to invite local reporters, do a ride-along, come to court, spend a day in court with a public defender and look at what's going on. And I guarantee that journalist will have, 20 stories by the end of the day, will understand the system with the public defender sitting there telling them what's going on. And, you know, again, as I said, that jargon thing, like stay away from that, and really try to talk about these issues in terms of the fairness and what's at stake constitutionally, to remind people that the reason we have public defense is to check the power of the federal government or the state government against individuals. And, you know, people understand that as a right. That is part of a conversation that's hot and heavy in the country right now. So it could be rephrased, I think, in more provocative and useful ways. You had your hand up, so sorry. Okay, all right.
Okay, we just want to stop 2 minutes earlier.
Thank you.
So you want to get your books done. Let's give a warm round of applause.